I made the statement, the rather uncontroversial statement, or so I thought, that a building that holds a court is a courthouse. I am amazed at the number of responses and replies and messages on Discord that I have received arguing rather absurdly that a building which holds a court is not a courthouse. Now this is a rather small group of definitions, but you could see that Google's dictionary says a courthouse is a building in which a judicial court is held. Merriam-Webster, a building in which courts of law are regularly held. Dictionary.com, a building in which courts of law are held. Cambridge Dictionary, a building that contains rooms where trials and other legal cases happen. Vocabulary.com, a building that houses judicial courts. The dictionary, the Free Legal Dictionary, or the Free Dictionary by Farlex, a building housing a county government's office or a county seat. Okay. A public building in which courts of law are held. Oh, there we go. Of course, they wouldn't have the most common. Oh, they did. Okay, I just missed it. A building housing judicial courts. It's early and I'm not wearing glasses, so sue me. The English Oxford Living Dictionaries, a building in which judicial court is held. The Leon Valley building that holds the city hall, the police department, and the municipal court is by all these definitions a courthouse. Is it other things as well? Yes. But is it a courthouse? Now, you can fight this. You absolutely can fight. This isn't my opinion that it's a courthouse. This is by the standard definition of the word courthouse. It is a courthouse. The only viable way that you could argue with any merit that it is not a courthouse would be if you produced a specific definition that's applicable in some way. Like if there's a Texas court ruling, like appellate court or Supreme Court or Court of Criminal Appeals court, that held that if a building holds a city hall and a court and a police station or something along those lines, or some combination thereof, that building could not be called a courthouse legally, then maybe you have an argument. Or if there's a statute that defines what a court can call a courthouse for purposes of applying court orders, then maybe you have an argument. But even then, it gets kind of weird because courts can do a lot of fun things with injunctions and court orders. And I'm not entirely sure that that barring a higher court ruling on it, that even a statute could really get involved too much, because if the court has a good reason, the court can do things as a court of equity that aren't necessarily spelled out in law. I don't want to go too far into the weeds on that, but let me just say that it wouldn't be a settled issue. Another fun argument I'm getting is that the Batosai could not have been arrested for trespass. He could have. He met all the elements of it. He could have been arrested for it. Now, when I say things, I actually typically mean pretty much what I say, especially if I'm making a statement that has a qualifier. Like if I said that the Batosai could have been arrested for trespass, what I mean is that he legally and lawfully could have been arrested for trespass. Would he have been convicted? That's an entirely different ball of wax. I'm not making any statements either way on that. There are a lot of factors that I'm just not aware of. A lot of it's going to come down to the voir dire to see who gets seated on that jury. A lot of it is going to come down to how good the various officers are going to be on the stand. Does Mr. Turner decide to take the stand or not? And if so, does it help him or hurt him? Would it be held? Would the trespassing? What court would that trespassing charge be heard in? And would it be heard by a jury or by a judge? I think a judge would be a lot more likely to just go down the strict definition. Just, did he meet the elements? Yes, 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 yes. Bada boom, bada bing, trespassed. You violated this trespass order. You were trespassed. You didn't leave. It was a criminal trespass. So please bear that in mind. And I'm not saying that he should have been arrested for trespass. Again, that's not what I said. I said he could have been. I think the officers, while they were really quick to trespass him, to tell him to leave, and one could argue that they shouldn't be that way. One could also argue it's reasonable considering what they've gone through with Padilla and the others who've gone down there. That, you could argue either way on that. But once they told him to leave, they didn't seem that they were all that eager to arrest him. And I think that's a good thing. I am always in favor of officers using their discretion to solve situations like the Batosai, where they could get him to a place where he is not and would not be, strictly speaking, in contempt of court, where he's in that atrium, in that little entryway place that, it's a happy little medium. He's separated by doors from all the stuff that's going on inside, so people can have their relative levels of privacy from being filmed or audio recorded. But then they don't have to arrest him because he's obviously not acting like a criminal. He's soft spoken, he's insistent, but he's not causing a scene in and of himself. If the officers didn't cause a scene, he wouldn't have been causing a scene. You know what I mean? So I'm not saying that he should have been arrested. I'm not even saying that part should be considered a courthouse. I never said that. I just said that by the definition, it is a courthouse. So if there's doors separating that area off from the court, I don't see why the court would make that area part of the courthouse, why it would determine that's part of the courthouse. But it can by the strict definition. So there's a world of difference between what I think the law should be and what the law is. My point in all of this is not to try to tell you what I think the law should be, although it does come out from time to time, but what the law is. And you could do with that what you will. But at least you'll know if you're walking a line or if you've crossed a line or if you're on a really safe side. So that's my intention. Do with that what you will and have a great day. Oh, also, if you're going to burn a flag, if you're going to burn anything in a protest, I strongly recommend talking to a lawyer ahead of time, a lawyer who's local, who knows the local ordinances, who knows the state statutes, who can give you a good idea of what potentially may happen to you if you do it. I'm not saying that in regards to a blue flag or the thin blue line flag. Personally, I am all in favor of free speech. I think you should be able to burn any flag not really any time, I guess, if there's like a fire hazard or something, but I'm all in favor of free speech, which includes flag burning of the U.S. flag or the blue line flag or whatever flag you want to burn. I support your right to free speech. That doesn't mean you won't be in violation of some other law, an otherwise neutral law, like you can't burn anything in the street kind of law that's not targeting speech, probably won't run afoul of the First Amendment if they arrest you for burning something in the street. You know what I mean? So be careful, talk to a lawyer, have a great day.